Good morning, everyone. We want to welcome you to today's webinar on our topic of employment law and freedom of speech. What can employers do when employees express their political, cultural, and social views? We had today our speakers, Arlene Yang and David Mehretu. And before we get started, I just wanted to cover a couple housekeeping items for today. We are in the webinar format of Zoom, so all of your cameras are turned off and your audio is muted. Should you have a question for our presenters with regards to the topics that we're covering today, please use the Q&A button located on your menu bar. If you have any technical questions or want to add some commentary to the discussion with other attendees, please feel free to use the chat box. I would like to say we will be circulating a copy of the PowerPoint, a copy of the recording when it's made available, as well as MCLE certificates by the end of the week. Another new feature we added are subtitles. So you'll notice a CC button on your menu bar, and feel free to disable that on your end if that's too distracting for you. With that, I'd like to hand it over to Arlene and David to introduce themselves and our topic for today.
Good morning, everyone. My name is Arlene Yang. I'm a principal at Myers-Nave. And for those of you who don't know, for over 30 years, Myers-Nave has been serving clients who are public entities, private companies, nonprofit organizations. My specialty is focusing on providing strategic and practical solutions for employers. So I help with advice and counsel, investigations, and also defending them in litigation. And now I'll turn it over to David to introduce himself.
Thank you, Arlene. Good morning, everyone. My name is David Mehretu. I'm of counsel at Myers-Nave. I'm in the trial and litigation practice group and the labor and employment practice group. My work deals extensively with civil rights and constitutional issues, covering First Amendment law, employment law, and land use litigation. I'm really happy to be here with my colleague, Arlene, and I just want to thank everybody for joining us here today. I think we have a really interesting session of some laws at the intersection of First Amendment law and employment law that we're going to get to discuss. So thank you, Arlene.
Great. If we can move on to the next slide. So as we are lawyers, I just wanted to give a little bit of a disclaimer. This is an informational section, and we're not providing you with any particular legal advice for your particular situation. We recommend that you consult with an attorney at Myers-Nave or another attorney to address any particular issues or problem. And I wanted to just, now that you know a little bit about us, we wanted to get some information from you. Our first poll question today is, have you had any concerns about employee expression of political, cultural, or social views? And you can say if it was yes, related to on-duty conduct, related to off-duty conduct, or no, you haven't experienced this yet. As we're getting the responses, I'll just kind of tell you a little bit about what brought us here today. So as we know, it's been quite a tumultuous year. We had a year where we had pandemic, and then there's also been a lot of division and polarization of views. So for instance, we had the murder of George Floyd last spring, which led to protests and counter protests. We had a very divisive presidential election. And then of course, we had the storming of the US Capitol. And that's led to a lot of discussions and questions about what people should do. Maybe we could go, yes, so we have, okay, so we've had only a quarter of the audience has not experienced these issues at all. And then there's an equal split between questions related to on-duty conduct and off-duty conduct. So we can go on to the next slide. So we've had a lot of division in the past year especially, and we've seen these problems come up in different ways. It could be where one coworker is complaining about the social media posts of another coworker. We've seen situations where a member of the public might be complaining about what a police officer was doing outside of work. And then we've also seen litigation. So just two cases that were in the news recently I wanted to bring up. There was one where Whole Foods was sued because they were not permitting their employees to wear Black Lives Matter masks, and that while they were working. So this was a Massachusetts case, and it's not quite on topic with some of the issues that we're going to be discussing today, but that's an issue. There was litigation as a result. And also recently there was a case filed where there was a computer programmer in California who attended the Capitol riots. And then when the employer found out, she was terminated and she's brought suit as a result. So we see there's litigation. We help with litigation. We help with advice and counsel, and then also investigating some of these issues. If we can go on to the next slide. With the next question we wanted to find out is what kind of issues are keeping you up at night? Is related to off-duty conduct that's in conflict with the mission and values, that you see complaints about on-duty conduct or off-duty conduct, or there's something else. If there's, you're free to include it in the chat. Everyone else may be able to see it as well then, and it'll just kind of give us an idea of what you've been facing. While we're getting some information on that, I wanted to see if we can move on and talk a little bit about our agenda today. We're going to be looking at, David is going to focus on first the constitutional framework and then federal law. I'll also be talking about state laws and some labor considerations. And then we'll be talking about some employer best practices and policies that you might consider. And we'll spend some time to go through some real life examples. And we'll try to have some questions at the end. The number one issue that's keeping people up at night is if the off-duty conduct is in conflict with the organization's mission and values. And then there's also other complaints about on-duty and off-duty conduct. Great. So if we go on to the next slide. One thing that I did want to do to start to just when we're approaching these issues, we want to address a couple recurring factors. And one is looking at the employee relationship. So is this a public employer or a private employer? Is there a union and collective bargaining agreement or not? And because that's going to affect how we approach the issue. Also, was the conduct off duty or on duty? So those are some of the basic issues. And then of course, we're going to be looking at constitutional and legal constraints and what the employer's policies are. We're going to jump right into the constitutional issues. So I'm going to turn it over to David.
Thank you, Arlene. If you could switch to the next slide, thank you. So jumping into the constitutional issues, as attorneys, we're all familiar with the First Amendment protections for freedom of speech. Generally, the government may not prohibit or punish speech. Of course, there are some well-known and well-established exceptions. Those include obscenity, libel, slander, what are called true threats, and then time, place, and manner restrictions. Next slide, please. So the First Amendment protections are pretty broad, and they extend to even what's called hate speech. Courts have extended the First Amendment protections to, for example, racist speech by Klan members in public demonstrations, Nazi marches, displaying swastikas and other offensive symbols, and the burning of a cross at a political rally. And so again, the extensions are broad for the general public. Next slide, please. As when an individual joins public employment and takes a job with a government employer, they don't essentially hand over their free speech rights. They still have them. At the same time, however, the government can control more of the speech of its employees than it could towards the general public. And that's just simply a necessary aspect of running the government enterprise. If it can't, do even some of the things that a private employer does for controlling speech and making sure that things are operating smoothly, it wouldn't be able to provide any services. And so what the courts have done, and the jurisprudence in this area has struggled or strived, I should say, to achieve a balance between the government's legitimate interest in its administrative operations and efficiencies with the free speech rights of its employees as citizens. Next slide, please. So the Ninth Circuit has developed a 5-part test that kind of combines the law in this area that's developed over the past 40 or so years. And the test is comprised of the employee's prima facie case, and then what the employer has to show to rebut that case. And this 5-part test, although aspects of it apply elsewhere in the free speech context and analysis here, really applies to where an employer is disciplining an employee for speech that occurred either on or off the job. And so the first 3 elements, and this is the employee's prima facie case, would be the employee needs to show that their speech was of public concern, which is obviously very different from the level of protection that somebody in the general public would have. You wouldn't need to show that your speech is of public concern for it to be protected under the First Amendment, but because this is that more limited arena of employee speech, the bar is a little bit higher. So the employee needs to show that there is a public concern to their speech. Second, they need to show that their speech was spoken in the capacity of a private citizen and not part of their official job duties. And then 3, the familiar just employment concept of they have to show that their speech was a substantial cause of an adverse employment action, such as being disciplined, fired, etc. Next slide, please. So once the employee has satisfied their prima facie test or made their prima facie case, the burden shifts to the public entity employer to establish that its own legitimate administrative interests outweigh its employees' free speech rights. And this is known as the Pickering balancing test, established in the Supreme Court's Pickering case from the 1960s. Alternatively, as the 5th element of the test, the employer could show that the adverse employment action would have occurred regardless of the speech. You know, for example, if an employee, broke a clear rule or just wasn't showing up to work, that could be a reason for disciplining them separate and apart from any speech issues, and that could be a way that the government could also satisfy this test. But for today's presentation, we're going to focus more on the elements that are unique to the free speech and First Amendment context. So we're going to focus on the concerns the public, private speech, and the Pickering balancing elements of the test. Next slide, please. So the first element is that the employee needs to establish that their speech was a matter of public concern. Generally, a matter of public concern is one that relates to the political, social, or other concerns of the community. It doesn't include purely personal issues, gripes, and grievances that may come up, whether they have to do with the workplace or outside of the workplace. So some examples illustrate this. A police officer's pornographic videos that he had shown online, not surprisingly, were not considered a matter of public concern and didn't get any protection. In other words, the employer could discipline the officer for engaging in that speech. An assistant DA's questionnaire that she circulated complaining about grievance procedures was also deemed to be something that was more of a workplace grievance and not something of public concern and not entitled to any protection. In contrast, where a fire department paramedic had posted on Facebook pretty offensive posts about killing liberals that even had racist overtones, the court said that the offensive nature of the speech it's irrelevant as to whether it concerns the public. And the fact that this had to do with gun control, it made it something of public concern, even or despite the offensive nature of the speech. And so that, at least at that level of the analysis, it was protected. Similarly, a police officer's Facebook post showing President Obama hanging in a noose and disparaging the Black Lives Matter movement was viewed as speech that concerned the public because it had to do with political criticism. Next slide, please. So after establishing the first element of public concern, an employee needs to establish that their speech was made as a private citizen as opposed to pursuant to their official duties. And this is really just effectuates the policy under the First Amendment in this context where it's not so concerned with employees' speech as employees per se, but their speech as private citizens being affected by their employment and their employer's rules. Next slide, please. So there are no sort of hard and fast rules here for determining when speech is speech made as a private citizen versus speech made pursuant to official duties. It's really going to be nuanced and fact dependent. For example, it doesn't matter if the speech is in the workplace or outside of the workplace. It's not dispositive if it is pursuant to the sort of official job duties of the employee. It's really going to just depend on all the different circumstances at play. So some examples will illustrate this. In one case, a teacher's class banner that contained messaging about religion was deemed to be speech from the actual school district because it was part of the curriculum of the school. And so the teacher could be disciplined for the banner, despite that it on some level reflected the teacher's personal views. Similarly, a coach who would kneel and pray at the 50-yard line after every game in front of all the spectators, students, and parents, and in his coaching uniform, was deemed to be engaged in speech pursuant to his official duties as a coach, not in his personal private capacity as a citizen, and he could be disciplined for that speech. In contrast, a police officer posted on Facebook saying that it was a shame that a suspect who had ambushed some of his colleagues didn't have any bullet holes in him. And the court acknowledged that although this was offensive speech and there were issues in terms of reflecting poorly on the police department, that this still was speech that was made as a private citizen, not pursuant to his official duties, because it wasn't his job to opine on how the officers had responded to this particular suspect or to take any action in that respect. Next slide, please. So once the employee has established his or her prima facie case, the burden shifts to the public entity employer to establish that it has some administrative interests that outweigh its employee's speech. And again, as I mentioned, this is known as the Pickering balancing test. So like all balancing tests in the law that we're all familiar with, there's no bright lines or hard and fast rules here. It's very nuanced and fact specific. But some standards and guidance has emerged from the case law. For one, the employer typically is going to have to point to something more than just speculation that the employee's speech disrupts their operations. Usually some sort of evidence of disruption or likely a disruption is going to be required. The Ninth Circuit has also acknowledged or recognized that there's somewhat of an implied sliding scale here, where the more significant the employee's speech, the more weight it's going to be accorded. And so this is kind of unusual in First Amendment law, where usually the government can't really inquire into the content of the speech. But in this, again, different employer-employee context for the First Amendment, the courts do allow that. And so just by way of example, speech that is critical of the employer, that may point out problems with the employer, such as corruption or things of that nature, are going to be afforded much more weight than, say, a racist rant that may just lightly touch upon an issue of public concern, which will be given a lot less weight. Next slide, please. The courts have also identified various factors that are relevant to the Pickering analysis. I'm not going to go through all of them, but some of them have to do with things such as the camaraderie between coworkers, how much public accountability an employee has in terms of their role, which will affect the impact of their speech, and just the general interference in terms of operations of the employer's enterprise. Next slide, please. So to see how the Pickering balancing approach kind of operates, and just to see how nuanced it is, let's look at several examples that largely come from the Ninth Circuit. So in one case, we mentioned it before, you had a SWAT officer who posted on Facebook commenting that it was a shame that a suspect who had been arrested after ambushing police didn't have any holes in him. The court, when it reviewed this case and reviewed the discipline that was imposed on the officer, found that the discipline was unconstitutional. Although it acknowledged that the public perception of the police department was very important, it cited the fact that the officer's post was not widely viewed. It had been taken down quickly after it had been pointed out. And there was no, and I think this was the key issue, there was no evidence of actual or likely disruption to the police department's operations. So the discipline was held to be unconstitutional. Similarly, in another case, a clerical employee had made a comment to a coworker about the Ronald Reagan assassination, basically saying that because he had carved away at welfare and food stamps, that if they tried to assassinate him again, she wished that they would be successful, or something to that effect. The court found that she could not be disciplined for this speech. It cited again the fact that the speech had not been widely disseminated. She just made the comment to a coworker. There was little to no evidence of disruption to the employer's operations. And as a clerical employee, she didn't have much public accountability. So this was not somebody who the public was going to be particularly concerned about in terms of her views on these issues. In contrast, we had mentioned a fire paramedic's posting on Facebook, which was both violent towards liberals and had racist overtones. The court in that case came to a different conclusion and sided with the government. And what was important for the court in that case was the fact that there was evidence of actual disruption to the fire department's operations. Various employees complained that they couldn't trust this employee any further. The court also noted that this employee had a high degree of public contact, and therefore the public's perception of having employees that were not biased was really important. So those cases just kind of illustrate just how nuanced the Pickering balancing approach is in this context. Next slide, please. So the First Amendment doesn't only apply to the context where the public entity employer is disciplining employees for their speech. It also applies to policies, rules, and regulations that may violate the Constitution, which are so-called prior restraints. And when you're evaluating whether a policy or a rule constitutes a prior restraint, we're going to use the same Pickering balancing approach that we just discussed. There is a difference, though, which is that the government's burden is actually even higher in the prior restraints context, because instead of just dealing with an individual employee in one instance of speech and weighing the competing interests in that context, with a prior restraint, the court has to look at, and the government entity has to look at, all of the different speakers who are conceivably going to be affected by the policy and all of the speech that it's going to affect. So next slide, please. This is a developing area of the law, and we're expecting to see more case law and guidance on this. But one thing is clear, which is that the Pickering balancing approach in this context is equally nuanced and fact-dependent. And I want to discuss two cases that illustrate that here. In a first case, a police policy prohibited the dissemination of information on social media that would, quote, tend to discredit or reflect unfavorably upon the department. And the court found that this policy was unconstitutional as a prior restraint, citing the fact that the language was just too broad and sweeping. It could include legitimate speech by employees critical of the employer, pointing out important issues for the public about the employer, and there was no constraint there was no limitation to that, and therefore it violated the First Amendment. In a very similar case, where a similar policy was at play, with the same sort of discredited and unfavorable language that the prior case had, the court actually found that the policy was constitutional. What was key is that the policy in the second case included some limiting language that provided that personal social media activity must not interfere with work duties or the operation of the department. And so for the court, that was necessary and sufficient for cabining in the policy and making sure it didn't unnecessarily chill speech that's protected and legitimate. Next slide, please. So we've been discussing the analysis of employee speech in the First Amendment context. Of course, the California Constitution also protects employee speech. However, the courts that have approached this and dealt with the California Constitution have found that it provides substantially similar protections as the First Amendment. And therefore, from a practical perspective, as public entity employers and for the courts, you're not going to have to do a separate constitutional analysis based on the California Constitution. Next slide, please. So just wrapping up this section on the constitutional framework, it might have been obvious in terms of how we've been discussing this, but the First Amendment and the constitutional provisions at play don't apply to private employers. Rather, private employers can discipline, they can have policies that limit and restrict speech, without any First Amendment implications at all. Where there are rules and regulations that do affect both public entity employers and private employers will be more in state labor laws. And that's exactly what we're going to turn to now. And Arlene's going to be discussing that area. So thank you, Arlene.
Great, thank you, David. We go on to the next section. I work mostly with private employers, although also with public employers. So I wanted to point out we have over 230 people in our audience today. And so it's a mix of public and private employers. So I wanted to point out for our private employers that we do have at-will employment under California law, which means that employee can be terminated for any reason or no reason as long as it's not prohibited by law. So that's kind of where we're starting at when we're thinking about the private employment context. If we go on to the next slide. Generally, as a general rule, employees do not have the right to engage in political activity during work hours. And then there's special rules related to public employees explicitly under Government Code 3207 and then 3206, which discusses about prohibiting appearing in uniform for political activities. So that generally it means employers have a right to control, what employees are saying and what they're wearing during their work hours. If we go on to the next section. But one thing that we do want to keep in mind is there are state law protections for political activities. Where most of you should be familiar with Title VII of the Civil Rights Act and also the Fair Employment and Housing Act. And both of them provide protections for certain types of things, such as protection based on race or disability or sex. But those statutes do not explicitly have any sort of political activity or political affiliation protections. Those protections come under Labor Code Section 1101 and 1102, which relate to prohibiting employers from creating policies or threatening to discharge employees based on any particular political activity or political action. And then we also have, if we go to the next slide, we see that the government code for public employees also has specific restrictions that are placed on the employer. So we have Government Code 3203, and then there's some other sections related to public school personnel and federal employees as well. So if we can go into the next slide. What's been interesting is to think about what is political activity. Of course, we would know that campaigning for political office would be considered political activity, but the courts have actually considered to be broader than that. So it could encompass espousing of a cause and action to promote acceptance by others. So it could relate to social, kind of political social movements as well. Some of the cases that we've seen show that it's not narrowly confined to partisan activity. And it could include things, there was a case actually where it was, this was from the 1970s and talking about someone's homosexual orientation, as the court put it, was considered to be political activity. If we can go on to the next page, next slide. I wanted to just bring up a couple examples of cases that have related to this. We have one case where a journalist, he spoke on a radio show opposing a candidate for public office, and he also criticized a member of Congress. Turned out that the publisher of the magazine, the publication, was a friend of the Congress member and also was supporting the candidate. So the journalist was fired and sued, and the court ruled that it was a violation of Section 1101 and 1102 because he was involved in activity that was off-duty conduct, and this conduct was protected. By contrast, this is a little bit similar to what David said before about a situation where the termination is not related to the political activity. Here we had a full-time financial advisor. He ran and was elected to be county supervisor in Kern County. And the supervisor role required him to work 25 hours during the business hours. And he was also supposed to be working full-time as a financial advisor. So the court said that it wouldn't be considered a violation because he wasn't available to work the hours when required. And in this particular case, they had warned him in advance of the election that he couldn't have both jobs. So we can go on to the next slide. And so you know, as with a lot of things in employment law, there's going to be a continuum of activities. So certainly, you know, direct political activity related to elections, we know that that's going to be protected. Hate speech is unlikely to be protected political activity. And then, you know, you can kind of run along a spectrum of what types of activity might be considered political activity when it conflicts with, you know, the organization's views or the owner of the organization's views. So I think quite likely Black Lives Matter mask at work might be considered political activity. And so then you just have to run through kind of understanding what happens. Can the employer tell employees they'll be fired if they attend a rally for Proud Boys? Then we start getting into some questions about, you know, is this an activity where they're planning for the overthrow of the government? Then it's likely to be something that could be prohibited. But if it's, you know, kind of a more peaceful protest, then, you know, you're tending more to be, you know, less, more likely to be protected. So there's kind of a continuum, and it's not a one size fits all or black and white situation always. If we can go to the next section, next page. The other law I wanted you to be aware of is Labor Code Section 96, Subdivision K and 98.6. And that is worded quite broadly. And it says that employers cannot discriminate or retaliate for lawful conduct occurring during non-working hours away from the employer's premises. And I've seen situations where plaintiffs have claimed that any conduct that they do, if it's lawful and it's not during working hours, that means that it's protected by the statute. What we've seen is that courts that have interpreted this have interpreted it to be more narrow and limited it to lawful activities protected by the Constitution or the Labor Code, and not just every type of activity that someone may engage in. But that does come up in cases. And then I wanted to just point out, if we go on to the next section, just to remember, there are many, many types of speech that are protected by other statutes. So for instance, under the Fair Employment and Housing Act, if an employee is reporting discrimination or requesting a reasonable accommodation, that speech is protected and there cannot be any retaliation as a result. Similarly, we have the Equal Pay Act regarding and so employees are permitted to discuss wages. We have the Crown Act, which was from a couple of years ago, which protects employees to have natural hairstyles. You know, that might be considered a form of expression. There are many, many whistleblowing protection statutes, and also the National Labor Relations Act. I wanted to bring a special note for that. Many employers do not have a unionized workforce, and they don't realize that they still need to comply with the National Labor Relations Act. And a lot of the times when that comes into play is where an employer is preventing employees from engaging in concerted activity or communicating with each other. And then if that's related to some way where they might be trying to, you know, unionize or something, or relating to their work conditions. So even if an employer is not unionized, they need to be careful and make sure they're complying with the National Labor Relations Act. And then if we go on to the next slide. And then I also wanted to just bring up a couple statutes that wouldn't typically come into play when in the employment context, but We did see it recently in that case. It was a light case where the computer programmer was terminated after attending the Capitol riots. And she alleged, among other claims, that there was a violation of the Tom Baines Civil Rights Act. So both of these acts are related to, often if it's prohibiting violence or threats of violence from someone from either because of their political affiliation, because of their race or other protected classes, or from exercising constitutional rights. So those, just to be aware that these statutes are out there as well, and those are potential claims that someone could bring related to free speech. And then we can go on to the next section. So I wanted to also just bring up some issues that come up with protests and when employees may be arrested at protests. We've had questions about terminating employees who are arrested at protests and what can be done. So, kind of like as I said from the beginning, it's important to think about what kind of situation we're in. Is this a public employer or private employer? Is there a union involved or not? Is this on-duty or off-duty conduct? Likely this was off-duty conduct. So just to kind of think about, we want to think about, there might be issues related to discipline that are outside the political activity. So for example, if someone is arrested and you haven't heard from them in 72 hours or something, sometimes employers have policies saying, if we haven't heard from you and you haven't shown up for work, you could be subject to discipline. So there might be basis to discipline someone that's unrelated to the political activity, but more related to the fact that they haven't come to work or reported to where they were. And I also wanted to point out Labor Code 432.7. That prohibits discrimination or termination based on just an arrest record or police report. So public and private employers are not permitted to just terminate someone because they were arrested. If they're thinking that discipline may be appropriate, it would be appropriate to have an investigation to determine what the facts are and make that determination for yourself and not just focusing on whatever the arrest record said or the fact that someone was arrested, because that could get you into trouble. And then also thinking about whenever you're thinking about discipline and you have a collective bargaining agreement, of course, even though this may be an unusual situation, you can't just discipline someone without going through the process, consulting with the union representative and just ensuring that you're abiding by the collective bargaining agreement. And then the next section, next page, right. So some things, so that was kind of a little bit about the state law issues that you want to be aware of when these kind of things happen. Then also you're going to want to make sure you have good policies. We recommend that all employers have employee handbooks, of course, and so certain policies are very helpful in situations when there has been a concern about the kind of speech that employees are making. So you want to have social media policies, and it's very helpful, especially with the private employer context, to make clear that to employees that if their off-duty conduct has a direct impact on the company's reputation or financial well-being, there may be discipline, and also to incorporate the anti-harassment and discrimination policy. Then we go to the next slide. And so when we're doing this, you're going to want to be remembering any kind of First Amendment rights that might apply to public employers, any kind of privacy rights. Also, the National Labor Relations Act, you wouldn't want to have any policies that are prohibiting employees from talking about their work conditions or infringing on their right to organize. I also wanted to point out this Labor Code Section 980B, which I actually hadn't heard of until I was starting to research this for this topic today, which is that employers cannot require or request disclosure of usernames or passwords to personal social media, or make employee access to social media in the presence of the employer. This is not related if there's an allegation of employee misconduct or there is a concern that there's a violation of law or regulation. Of course, then the employer can require access. But if you can't just randomly be accessing employee social media if you don't have a reason that you need to know that information. So having these policies will make it easier. So for instance, if you have a employee who is violating the social media policy, then you can tell them you agreed to, when you started, you were assigned the handbook, acknowledged that you accepted the policies, and you were not permitted to do this. And so that could be a basis for discipline. But if you don't have any sort of policy, it makes it much more difficult to say that they did something wrong or that any policies were being enforced evenly across the board and not just in particular because of this particular speech. So having those policies in place helps to have discipline later if you need it. If we go to the next slide, there can also be dress code policies that may be helpful if you want to prevent employees from wearing certain types of slogans or information, words or images during work hours. That can help to let people know what the rules are, and then you can enforce it afterwards. But of course, you can't have dress codes that are discriminatory. Kind of on an aside, having different policies for men and women about what men and women could wear, that kind of thing can get employers into trouble. And then the next slide. So there can be other policies that may be helpful as well if you have concern about people having political slogans or controversial statements that are posted on the walls or in their cubicles. You can have policies about office decor. And then especially helpful, and we did see some questions about this, is technology usage policies to make clear that, because I've seen a number of cases where employees are using company or organization resources to post messages or post pictures that might be pornographic or in violation of the anti-harassment or discrimination policies, using, whether it's on or off duty, if they're using company equipment, employees need to know that they could face discipline for using company equipment to take actions that would be in violation of its policies. So it's important to have those in place in advance so that employees are aware of what the policies are, and then if there's a problem, you have a basis to explain why discipline is appropriate. And then the next slide. So we thought we'd spend a little bit of time to talk about what kind of things that we've seen and examples that have happened in real life and how we can approach those problems. So David's gonna go with this next one. I love that that picture of the bumper stickers.
Thank you, Arlene. So yeah, as Arlene mentioned, we've wanted to take a couple of sort of hypothetical examples, but they're really based on real life events, real instances, at least one of which I'm sure most people will find to be familiar here. But I just wanted to generally go over what the fact pattern is, and then we'll talk about how a situation like this might be analyzed from kind of that constitutional perspective and framework that I was discussing earlier, but also some of the other state law issues and practical issues that Arlene has been going over just now. So in this first example, we're dealing with a police officer expressing far-right views. So a police officer parks his personal vehicle in a city parking lot. The vehicle has decals for the 3 Percenters, far-right militia group, the Thin Blue Line, American flags, a Trump sticker, and one mocking the LGBTQ community. So 6 months later, the same police officer posted messages on social media platforms saying, expletive Black Lives Matter, and to free Kyle Rittenhouse, who shot and killed 2 protesters in Wisconsin following the shooting of Jacob Blake. So, taking this as the kind of instance that may face an employer, how should the employer start to analyze this and look at this? So if we could just go to the next slide, please. So first, from the constitutional perspective, there's going to be the following questions that we went over. First, is this a matter of public concern? Although there's a mixture of messages and issues in that hypothetical, courts would probably view this as a matter of public concern because issues like Black Lives Matter and a thin blue line, all of these issues have to do with matters that the public is concerned about with policing. And so even though there's some offensive mixed messages in there, as we discussed, the offensiveness of the speech isn't relevant to whether it concerns a matter of the public. We'll also want to look at whether this is private speech of the officer versus the officer's speech in the context of his official duties. And again, court's likely to come out here with finding that it's private speech. The officer's job isn't to address these issues as part of his or her job. These are his or her own private views. And that would then take us to the Pickering balancing test that we discussed. And that's going to raise a bunch of different issues, such as, how many people saw these these instances of speech? Did, were there complaints? Was there any actual disruption? Is there any evidence of that? So a number of those factors are going to have to be looked at. And those are going to be balanced with a police department's legitimate concerns in terms of making sure that the public views the police department as being unbiased, in terms of morale and camaraderie in the police department, which has been identified as a very legitimate interest for the government, making sure that this kind of speech does not create problems in the workplace. So that would be sort of how you would look at this from the constitutional perspective, just kind of in summary. And then I'd like to turn it over to Arlene to kind of address some of the other issues in terms of state law and policies.
So another thing that the employer is going to want to consider is, are there any policies that might cover this behavior? And is it in violation of the policy? And not only do you have to consider whether there's a policy, you have to consider whether the policy was consistently applied. So for example, if the policy is only applied to someone who's expressing far right views, but not someone who's expressing far left views, then it's opening the employer up to risk if they try to enforce the policy unequally to, depending on what someone's views are. And then the employer is going to want to have an investigation to determine exactly what's happening here and make sure that the employee has an opportunity to explain what's going on and what happened. And then there's also, you need to have a consideration, really, sometimes these situations come down to an issue of risk management. So you want to think about what's the risk of taking discipline and possibly terminating the employee as compared to the risk of not taking any action. So sometimes there may be some question as to whether it's appropriate under the law to, there could be a question whether you should terminate them or not. But then sometimes the employer will say, well, the risk of, if a lot of people are aware of this and the risk of what people's views of how the police department is going to be viewed is, that risk is greater to not discipline someone than to discipline. So there's some risk management issues that you're going to want to take into account. And then of course, because the police officer is a member of a union, you have to think about what the collective bargaining agreement says and what kind of process you need to follow if you're going to be considering discipline. And then we can turn to the next hypothetical or real life example. This one you may have seen. It was from 2000, I think this was in 2017. We had a government contractor in Virginia was going for a bike ride when Donald Trump's caravan drove by and she gave them the finger. that was captured by some press reporters, and she used this photo as her profile picture on Twitter and her cover photo on Facebook. So this was an interesting time, right? Because this was a federal government contractor, and they knew that the president would likely engage in retaliation if no action were taken of her, and she was eventually terminated. She said, and then she sued afterwards. She said that the company had feared retaliation from the Trump administration, and that also another employee had obscene content on his social media, but was allowed to remove it rather than being fired. So if we, I thought David could start with taking a look at what the constitutional issues might be if she were a public employee.
Thank you, Arlene. So, in this instance, the fact pattern this was based on had a private contractor, but let's just say this was a public entity employer. Again, we're going to be looking at whether the speech concerns the public. Here, because of the intersection with the president, a court could likely find that it does. Is it private speech versus part of the employee's official duties? Again, giving the middle finger to the president's unlikely to be found to be part of her official duty, so probably would satisfy the private speech element here. And that would then get you to the employer's burden of establishing that its interests outweigh the employee's speech. And so here, some of the things that I think we need to ask ourselves would be, did this actually cause any disruption to the public employer, right? If it did, then that would be something that would weigh heavily in favor of restricting the speech, especially because here, giving the middle finger to the president, although it might make a statement, is not necessarily, as that Ninth Circuit sliding scale recognizes, probably on the highest order of speech. But again, these issues are going to be very debatable, very nuanced. And so we're going to have to look at that a little bit more in terms of all the facts that come into play here for the constitutional analysis.
Right, and one thing I also did want to notice, especially in the context of public employees, is where you have a situation where social media posts, they're different posts on the same webpage indicate, for example, that if a person is a police officer, they show pictures of them wearing uniform, and then they post other pictures that would be considered inappropriate, such as some sort of racist comments. The connection between the employer and the outside conduct is much closer, and it's more likely that the employer has a good reason to discipline that employee for that kind of behavior. And so the fact that this employee was, if she had this, I mean, I've seen posts where people have their LinkedIn page where they identify their employer and then their photos show some sort of inappropriate activity. That's very closely then tying the activity that might be considered inappropriate with the employer, and there's a better basis to discipline.
Yeah, and just jumping in on that note, Arlene, a related issue is, the level of public accountability of this employee. So for example, we recall that issue of the clerical employee who made the statement about the Ronald Reagan assassination. If this is an employee who has more of a larger public interface, that could be different because it would suggest more of a interruption of the employer's operations versus perhaps someone like a clerical employee at the government entity.
So we did get a question about whether the middle finger situation how that would play out with the labor code and whether that would be considered political activity. And I think that it may be more difficult to say that it is just, I think it could go different ways. She's expressing her displeasure with the policies of the president. She could be saying that, but then at the same time, it could, you could interpret it other ways. So it could be a difficult situation to analyze, and there's not necessarily a clear-cut view. Right, so someone has said, I don't see that putting up your middle finger would be considered threatening. So, you could see different views about how someone might approach it. And I think it is an interesting and challenging time because our society and discussion has become so polarized. So some things that might be considered innocuous, like saying that Black lives are important, some people consider that to be, inflammatory or somehow, expressing a view that's radical. So you kind of have to, I really encourage you to consult legal counsel when these kind of issues come up, so that you can kind of work through the issues and determine the best direction to go. Right. So someone else suggested she could be flipping them off because they got too close to her on her bike ride, right? So there are different ways you can approach it, and one picture is not always telling the same story. If we can go on to the next slide. So we're going to give you a little bit of takeaway advice. We might have time for a couple questions, so if you have any, please feel to include it in the Q&A right now. But we wanted to just give you some takeaway advice. I think David was going to start.
Yeah, so one of the key things that I think obviously we talked about with the constitutional framework, there's a lot of nuance and it's very fact dependent. So that makes it difficult to kind of take away any sort of cut and dry points. But one of the things that I think is really going to be important, especially in the disciplinary context, is to identify any evidence of disruption and really articulate what kind of disruption the speech has caused or is likely to cause. That's going to help in terms of being able to justify any discipline after speech. And then in the context of prior restraints, if you have a policy, look at it very closely and carefully, or in the drafting of it, to make sure that it's not overly broad, so that it doesn't chill speech that a court's going to determine is legitimate, which also opens up the public entity to Monell violations, which has broader implications and costs for discovery. And so we just want to be very careful about that. Arlene.
Right, and so, but even though you have to be concerned about prior constraint issues, we really encourage that you do have written policies, especially concerning social media, dress code, et cetera. And having handbooks, keeping them up to date is helpful. When incidents happen, it's important to have a prompt investigation. You want to document, so that if you ever come up with a situation where you're involved in litigation, you have contemporaneous records explaining why you did it and the basis for it. And also keep in mind any collective bargaining agreements if you have unionized employees, and also to consult legal counsel, because as you can see, some of these issues are quite fact dependent and may, it can be difficult to navigate on your own. We did have one question about using Facebook posts as evidence in disciplinary matters and whether that's problematic. And no, that's it's okay to use Facebook posts as evidence in disciplinary matters. And certainly if we have cases that go into litigation related to a termination, one of the things that we do right away as soon as we can is look at their social media, see what they've been posting, because sometimes what they're posting will support the employer's decision. And
do we want to move to the next slide, Stephanie?
Yeah, so we're almost at our very good timing. We have about 1 minute left. So we can, if you have additional questions, feel free to reach out to us and we can respond to you afterwards. I also wanted to, if we can go to the next slide, I just wanted to let you know, this is primarily aimed at public employers, but coming up, I don't know if you want to talk a little bit about your First Amendment practice, David, and the work of Deborah Fox.
Yeah, so we're going to have thank you, Arlene, another presentation on social media, the First Amendment, and government. What are the new rules of engagement? And this is going to get into more of the nuts and bolts of First Amendment jurisprudence in terms of public forums and how public entities need to handle, and their elected officials need to handle things like unfriending people on social media and limiting and policing what's said in public forums. So it's going to be a very interesting presentation, and that's going to be on March 24th by Deborah Fox and Meg Rosequist.
We also did have a question about private employment and COVID issues, and you are very, you know what we're thinking. We are planning to do one of those in about a month. So if you're getting Myers-Nave emails, you'll find out the exact date, but we're with the vaccine coming and more businesses are going to be thinking about bringing more employees back to work. We recognize that return to work issues are going to be very important. So we'll stay tuned and we'll be talking more about those issues.
Yeah, and just I want to note there were a couple of questions I don't think we were able to get to. We've tried to answer some of them as we've been going. We will reach out to you to answer those, but reach out to us if you have anything else further after today, please. And thank you everybody for being here. Thank you, Arlene. Thank you, Stephanie.
Yeah, thank you guys. Just as a wrap up, we will, we will circulate the PowerPoint, so that'll be coming out by the end of the week, as well as a copy of the recording once the video is finalized. Additionally, MCLE certificates that anybody requested. And then I would also like to point you to our website. So we have a lot of good resources on there. We have a webinar page that also hosts our webinar recordings, as well as regular client alerts. If you haven't signed up for our client alerts, I encourage you to do so. Those not only include new legislation and laws, but those also will make sure you get the invitations on future webinars. So thank you, everyone. Thank you to our presenters, and we wish you a good rest of the day.
Thank you.